I moved into the neighborhood because it promised quiet streets, tall maples, and a community that actually cared about keeping its values. I liked the way the porch lights lined up like attentive sentries after dusk. I liked the way people waved from a distance. I did not expect to be the target of a vendetta led by a small group of neighbors who thought their rules were more important than the law. What I also did not expect was that the person they wanted to throw out of my own yard was the judge who could shut the whole charade down. The first exchange was petty. A letter slipped under the gate accusing me of placing unauthorized structures near the easement. The language was formal, too formal for a neighborhood dispute, typed on HOA letterhead with an ominous list of possible fines. I replied politely, asking for specific citations and the governing documents they were relying on. Silence. Then more letters, then threatening emails. Their president emailed me at midnight warning me I would be subject to enforcement action if I didn't comply immediately. I tried to handle it like any reasonable neighbor. I went to the monthly meeting and asked the board to explain which clause I had violated. I asked for their interpretation in writing. I asked about their authority to levy fines without notice. I asked how enforcement actions were initiated. I kept the tone measured because escalation was the last thing I wanted. I thought this was a problem that would be solved with conversation and paper. It wasn't. One humid afternoon, two security officers hired by the HOA appeared at my gate. They were polite enough, but there was a buzz of righteousness in the way they spoke. They handed me a document, a demand to remove signed by the HOA president, and a notice they had referred the matter to local law enforcement for trespass. I told them I had not received any due process and that I had submitted a written request for clarification weeks ago. The security officers said they were just following orders. They left, leaving a paper trail and a sour taste. A week later, I came home to flashing lights in my driveway. Two patrol cars, two officers, and a woman I recognized as the HOA president standing at the sidewalk with a notebook. She looked triumphant, like she had just struck a decisive blow. One officer explained that the HOA had filed a complaint alleging trespass and that they'd been asked to issue a notice. I asked to see the complaint. It was handwritten and vague. Property encroachment. No legal description. No evidence. No boundary survey. No notice of hearing. The officers were professional and apologetic. They said they had to follow protocol when the HOA alleges criminal trespass because it's a complaint from a private person. The humiliation cut deep. Neighbors drove by and slowed down to stare. Someone took a picture and posted it on a community page with a caption that assumed guilt before facts. The president circulated another email to the neighborhood suggesting I was acting outside the community's norms. It felt personal. It felt vindictive. It felt like a trial by gossip. That night, I sat on the porch with a mug of coffee and read my correspondence again. I was tempted to act in the shorthand way the internet often does. Retaliatory posts, dramatic confrontations. But I had spent my career in courtrooms where facts mattered and procedure was more powerful than fury. I wrote a calm, carefully documented letter reiterating my request for the governing documents they relied on, for a copy of the complaint they had filed with the police, and for a formal hearing before any enforcement. I sent it certified mail. I saved timestamps, emails, photos, and conversation logs. I was building a record because records win when tempers cool. A week later, the HOA took the nuclear option. They filed a civil trespass claim with the county and accused me of willfully obstructing access to a private common area. The claim was sloppy, relying on a misread plat and a garden edging that clearly sat on my property. But the complaint was public. The name of the plaintiff, HOA Board of Directors, appeared in the county filings. Social media amplified the accusation. Neighbors texted and asked if everything was okay. The president's husband stopped by with a smug, "We're just enforcing the rules" smile, as if the moral high ground was a permanent residence they were never going to vacate. I didn't react on social media. I drafted a motion to dismiss, on jurisdictional grounds, on lack of standing, on procedural deficiencies. I prepared affidavits showing that the area in question was clearly within my property lines, and I had a surveyor willing to swear to it. I submitted everything through the proper channels. The HOA responded with more bluster and a request that I remove my garden bed immediately or face consequences. Then, one Saturday morning, the HOA resorted to their most audacious move. They called the sheriff's office, claiming that I had trespassed on common property earlier that week and asking for an immediate arrest. They painted a picture of a neighbor who was belligerent and refusing to comply with community standards. An officer arrived at my home with a postcard saying I was requested to appear at the sheriff's office. I calmly called the officer, asked for the complaint number, the name of the complainant, and the statute they were relying on. The officer read from the file, and I listened carefully. The complaint was the same vague, hand-scribbled note, signed by the HOA president. The officer explained that their role was to investigate and that an arrest could only be made if there was probable cause. At that point, I did something I'd never thought I'd have to do in my own neighborhood. I identified myself as the presiding judge for the municipal division. The air in my living room felt suddenly thin. I could hear, even from the other side of the phone, the recalibration in the officer's voice. I was not trying to leverage my position to intimidate. I was offering clarity. The law still applied, and so did procedure. The officer agreed to take the complaint seriously and to investigate the factual basis for the alleged trespass. Word spreads fast in small communities, and before the sun had set, the HOA board convened an emergency meeting labeled Enforcement Strategy. Their emails called me a problem that must be addressed. They began to think they had the right to run roughshod over anyone who resisted. They had misread the tone of the neighborhood, and they had misread me. I wanted to win on law, not on drama. I continued to collect evidence, purchase documents, the recorded plat, the original survey, communications with the board, and the records of their attempts to escalate. I had neighbors who were quietly angry at the way things were escalating. A retired teacher brought over old minutes that showed the HOA had never previously attempted criminal enforcement for landscaping disputes. Another neighbor confessed that he'd been pressured to sign a form without reading it. The more I looked, the more it became clear that the HOA's tactics weren't about property lines. They were about power. The sheriff's investigator interviewed witnesses, reviewed the plats, and requested that the HOA provide their legal basis for criminal allegations. The investigator came back to me and said the HOA's claim lacked probable cause. My relief was immediate, but I knew vindication in the police report was only the first step. The HOA had already damaged my reputation and disrupted my life. I had to decide how to respond in a way that would prevent recurrence and protect the neighbors who might be next. I filed a counterclaim for declaratory relief seeking a court order declaring the property lines and enjoining the HOA from initiating unfounded criminal complaints. I also moved for sanctions against the HOA for bringing a frivolous case and for abusing process. I knew motions for sanctions were rarely granted, but I also knew the court did not take kindly to parties who weaponized criminal complaints to harass neighbors. At the first hearing, their president appeared with a stack of notes and a demeanor that suggested righteous indignation. She told the judge that she was just protecting the neighborhood. I listened, then I calmly explained the record. The HOA had failed to give proper notice, failed to follow its own enforcement policy, and had relied on hearsay and a misread plat to escalate to law enforcement. The court asked them for evidence of the alleged trespass. They produced a garden photo taken from an angle that made the bed look like it encroached on the path. They produced no survey, no expert affidavit, no certified copy of any deed or easement granting them the power to dictate who could plant what inside a private property owner's fenced yard. We subpoenaed their governing documents and enforcement procedures. The true heart of the problem emerged. The board had extended their enforcement authority beyond what the covenants allowed. They had been operating in an informal, ad hoc manner, emboldened by a few neighbors who wanted to control aesthetics rather than follow the process. And when someone pushed back, rather than engage in dialogue, they reached for law enforcement. The judge presiding over my preliminary matter was not surprised by the lack of procedural footing. The judge's questions, the tone in the courtroom, it felt like the scales were finally balancing. The judge ordered that the HOA's enforcement actions be stayed pending a formal boundary determination and ordered them to retract any public statements implying I had committed a crime. The judge also set a hearing on the HOA's alleged abuse of process. That was the turning point. The neighborhood started to whisper less and listen more. Some of the neighbors who had been allies of the HOA came forward and admitted they had been pressured. The president's facade cracked when the board's minutes revealed that they had instructed a vendor to pursue aggressive enforcement without consulting counsel. The more the facts were revealed, the more the board had to explain. Their explanations were weak, and their moral authority evaporated. I had to be careful. Being a judge did not mean I could use my chambers as a bully pulpit. I could not attack the HOA in the press or threaten their members with retribution. The obligation was to apply the law and let the system restore order. So I focused on legal remedies. A permanent injunction preventing the HOA from initiating criminal complaints except through a defined, documented process. Reimbursement of my attorney's fees for defending against the baseless actions, and mandatory mediation to revise the enforcement procedures so they complied with the covenants and state law. The mediation was tense. Board members tried to justify their actions as protecting property values. I argued that property values are protected when rights are clear and enforcement is fair, not when power is exercised arbitrarily. The mediator helped the parties draft an enforcement policy that required written notice, an opportunity for a hearing, neutral fact-finding, and a prohibition against referring neighbor disputes to criminal authorities without a documented basis. The HOA agreed, under the shadow of potential sanctions and the public embarrassment of a lawsuit. But legal remedies only fixed the structure. The human element needed care. After the injunction, I reached out to the neighborhood with a letter explaining the situation. Not to gloat, not to lecture, but to invite a reset. I wrote about the importance of civility, of following rules, and of making space for differences. I asked neighbors to come to an open community meeting where we could talk about expectations and the importance of due process. A surprising number came. Some who had cheered the HOA's early actions apologized when they realized they had amplified something without checking the facts. The president of the HOA resigned a month later, citing health reasons, but it was plain the pressure and the breach of trust had taken its toll. The board that replaced her moved to adopt the mediated enforcement policy, hired a professional management company to handle complaints to prevent escalation, and agreed to transparent minutes and regular audits. The security officers were put on notice that they must coordinate with the sheriff's office and verify complaints before making any show of force. The community installed a suggestion box, and the next annual meeting adopted a code of civility. Okay, a year later, at the community picnic, I stood with neighbors who had once marched against me, and we laughed about small-town dramas. The maples were taller, the porches brighter, and the lessons of the preceding months had been distilled into a single, quiet truth. Authority without oversight is a brittle thing. It breaks easily. But when you apply clear rules, hold people accountable, and give everyone a chance to be heard, communities can heal. The HOA learned the hard way that you don't get to weaponize the law to enforce tastes. The community learned the harder lesson that civility must be cultivated. I learned that patience and records often matter more than anger. And if anyone ever asked whether being a judge had made the difference, the answer was simple. It didn't. Respecting the rule of law did.